Okay guys, good morning. So over the next couple of classes we're going to talk a little bit and think a little bit about some of the legal issues that might have an impact on you if you're publishing stuff on the web. So a lot of this is fairly abstract stuff, but of course it's only abstract until you get a letter in the door from a solicitor somewhere, threatening to sue the bejesus out here. So it is, it's abstract but relevant and real just the same. So in the US, for example, there is a very strong and a very long tradition of free speech. Free speech all the time though, people outside nattering on. So, and the Americans even amended their constitution to specifically put in freedom of speech and freedom for the press. And that's kind of hard baked into their institutions and into the society in some respects. They're very serious about their freedom of speech and freedom of the press, and they believe very strongly in that, and it has stood to them. In different countries, of course, there are different realities. In some countries it's not as strong, but in many Western democracies, the idea that you can criticize the government or express your opinions freely are generally things that are considered important. And there's also a tradition in many Western democracies of the press being free to largely publish whatever it wants and criticize the government or scrutinize policies and things like that. And so that's both of these things are really considered linchpins of the democratic process. So you might find in other countries that the press isn't so free. So Russia, for example, would probably be a topical example these days. There are probably very few media outlets in Russia at the moment criticizing the Russian government's annexation of Crimea, for example. Whereas if Ireland was to annex Northern Ireland tomorrow, you might find that there would be considerable public debate as to whether that was a good thing or a bad thing, and you might have dissenting views. In some societies, there is very little dissent. It's hard for us, we're so lucky really, it's hard for us to imagine what alternatives might be like. It's hard for us to imagine what it might be to live in a society where you can't largely say whatever you want and where there isn't freedom of the press and freedom of speech. So it raises interesting questions then when you're publishing online. The internet, of course, is largely borderless, and so this upsets a lot of governments, because if they don't want people, you can control the newspapers very easily. You can throw people in jail for speaking out. But if people can have anonymous blogs that people can read, it's a big problem. So the internet has been quite a force for change in some parts of the world, and we saw that recently with the Arab Spring. Interestingly, in the US, there developed a practice over time where journalists had specific privileges. So if journalists, for example, got some information, it was generally considered that it was good for society that journalists would be able to keep their sources secret. So in the US for many years, journalists have had a kind of a privilege like Catholic priests might have in confession, where if they come by information, they would, be able to protect their sources, and you'd have journalists going to jail and things to protect their sources and things like that. Many US courts now have started to consider bloggers to also be journalists, that blogging can be a form of journalism, depending on the situation. And so that has had some interesting consequences. Now, what we're interested today, though, is looking at the limits to free speech that you might have. And there are a number of constraints. So it's tempting to think you could say whatever you want about whoever you want, wherever you want, and screw them, there's nothing they can do about it. But that's not quite the case. It's obviously, particularly if you live outside the US, it's certainly not the case. If you live in Russia or China or many other places, you may be constrained. What we're interested in today is the constraints that might be on you living in Ireland and blogging in Ireland. Even people who would believe very, very strongly or very absolutely in concepts of free speech might argue there are constraints and there are limits. A classic example people talk about is, can you stand up in a crowded movie theatre and shout, "Fire! Fire!" And have a panic and have people, crushed as they rush out the door? I mean, that's speech. Should that be allowed? Or is that wrong? Should we not allow that? So there are scenarios, there are constraints. The most relevant one, I think, if you're publishing online, is libel. And so a libel is a published false statement that's harmful to someone's reputation. Now, laws vary from country to country. So we're speaking very generally here. Because, of course, one of the problems with the internet is that it's pan-national, it's transnational. So if you publish something on your blog, you may well be libeling someone in Australia, and under Australia's libel laws, you may have wronged them there in a way that you might not have in Ireland or in the USA. Although, as it turns out, the libel laws in Ireland are pretty strict, pretty constraining. So you're more likely to libel someone in Ireland than you are in many other places. Now, so libel can be a noun or a verb. So you can talk about a libel. You could talk about a libelous statement, or you could even use the verb to libel someone. So it's a noun and a verb. In the old world, where the only people that published things were, say, newspapers, then they would have had lawyers that would check things. They could run stories by lawyers and say, is this libelous or not? Do I have sufficient evidence to run with this story? But nowadays, anyone can publish. One of the mistakes people make is they think, well, just because I'm publishing something on Facebook or on Twitter or on a blog, I'm not constrained by these rules. But in fact, you are. So posting something on a blog is also considered publishing. Tweeting something is publishing. Depending on the jurisdiction on the country you're talking about, there may be a distinction between publishing something in written form or announcing something publicly. If, for example, you're in a room with someone and you say something untrue about them that's harmful to their reputation, and they're the only person in the room, they might not like it, but you haven't libeled them. It must be a public statement, a statement that's available to many people, or to, well, not many, but more than other than the person you're talking about for it to be libelous. And generally, obviously, it needs to be false. So if you say something about someone that's harmful to their reputation and it's true, well, that's just tough, like, if it's true. So in general, the best defense against a libel claim is actual truth. If you can demonstrate that what you said was actually true, well, then you're safe enough in libel terms. Also, if something is obviously an opinion that's not claiming to be a verifiable fact, then you may be off the hook also. But like I said, it'll vary from country to country. The online course that I got you to take, that News.eu course, was very good on things like this. It was very good on this particular issue, although it was very US-centric. However, in most of the English-speaking world, a lot of the same principles have developed because they would have come from common law or from English common law or directly from English law. In Ireland, we had lots of laws that predated the formation of the state, but we've kind of updated them, but we're still generally the same principles. So I'm just speaking generally here now. It'll vary a lot from country to country. So if you're expressing an opinion, so if you say Colin Manning is a bollocks, well, like, that's clearly an opinion. I mean, it's not like I could go to court and say, well, Your Honour, I'm not a bollocks, and I can prove it, So that was clearly, a lie. If you said, Colin Manning passes student in exchange for drugs or sex or something, Well, that's not true, for starters, and it would be very damaging to my reputation as a lecturer. I mean, if you're a lecturer, or if you're, say, a politician or a journalist or a public person, your reputation is very important. So if you were to go around saying that about me, you would be libeling me, and I could probably take you to court and, get money off you. If you were to say that I was passing students in exchange for drugs, you would need proof of that. It would be on you to prove that that was true. It wouldn't be up to me to prove that it's not true. But you can see how something like that would be very damaging. So, if you do think someone is a bollocks, it's very important that you couch it in those opinionated terms rather than saying something that's specific but not true. A person who believes they have been libelled would have to go to court and then show that there was some damage done. There have been one or two very unusual, very rare cases. I have some handouts for you, which I'll bring the next day, of scenarios in which a court has ruled that a person's reputation was so bad anyway that you couldn't libel them. So if people had a very low opinion of you anyway, then what's the deal, Also, you can't libel a dead man, which is often a significant fact. Okay? It's also possible to paint someone in a bad light without actually making a statement. This can often happen whereby you're publishing a story or something in which all the information, all of the statements, all of the claims you make are perfectly true, but you cast someone in a bad light by accident. So let's say there's a picture, a story in the Irish Times about the shocking trend of lecturers passing students in exchange for drugs and sex. Right? It'd probably be more in like, a News of the World type paper maybe than the Irish Times. But anyway, and let's say, we need a picture of a lecturer now to go with this. And so they Google, lecturers, Ireland, and there's a picture of me in class. Oh, look, there's a picture of a lecturer there. We'll slap him in there. It'll be grand. Even though they would never have said anything about me, by putting my picture with that story, that's sort of implicating me in that when I'm just, a guy in a picture they found. And so you have to be careful. There's certainly a tendency or an ability of people online to be really nasty and mean, actually, in ways that they wouldn't be face to face. I don't think people have thoroughly studied that yet, but I think we could all agree it's kind of a phenomenon that we've experienced. So it is important to be careful, because the maybe cultural and social norms that might be okay, that might apply to Facebook or the web, will of course be judged by the rules that apply in the rest of society. And so you can't go around saying things about people that aren't true, that would be harmful to their reputation. What's important as well is that a libel doesn't just occur the first time the false statement is made. A libel also occurs every time it's repeated. So if someone libeled me and you repeated that libel on your blog or in public, you would also be libeling me. And that can have implications for people publishing online. So if you have a tweet, if you read a tweet that's libelous and you retweet it, well, then you are also libeling the person. If somebody publishes something that's libelous and you link to it, you might also be implicated in some way. You're distracting me there, guys. Do you want to close that down? So there have been some interesting cases, and I'm going to give you a handout on those. The most famous, I suppose, libel case on Twitter would have been one that, or an issue that came up with a guy called Lord McAlpine, where this is an interesting question to see if I repeat what happened. Am I libeling him? Obviously, what happened, the claims made against him were false, but people were retweeting them, and he was suing the people that made the original false claims, but also the people that tweeted them on, that repeated them. And that was an interesting case. So I have a handout on that, which we can look at the next day. Possibly the most famous, well, not most famous, certainly most important libel case ever was one 50 years ago, in which Sullivan, who was a police official, I think, in the Deep South in the US, was suing the New York Times for libeling him. The New York Times accepted an ad from some civil rights leaders. So this would have been the time of Dr. Martin Luther King Jr. and the civil rights movement, and big problems in the southern states in the US. And so the New York Times published an ad, which is kind of a letter signed by civil rights leaders, and it was fairly critical of the governance of the southern states, and in particular the policing of the southern states. And so this gentleman, who wasn't actually named, but he was implicated, took a libel case against the New York Times. And ultimately, he lost. One of the problems with the New York Times had was that some of the details of what was published was actually incorrect, but not in any significant way. So one of the mistakes they made, for example, they talked about the number of times Dr. King had been arrested. And it was actually, they had the count wrong. But the point, the essential truth of what they were saying, that he wasn't really getting a fair shake from police in the southern states was, the essence of that was true. So Sullivan eventually lost in the Supreme Court, and this changed things quite significantly, because had he won, the way in which the civil rights struggle was reported in the newspapers would probably have been very different. But because he lost, it sort of reasserted the right of newspapers to criticize the government and the way things are being done. And I mean, many people in many Western democracies would consider that to be a vital part of what a newspaper does and what journalists do, is to scrutinize the way the country is being run. So this was a very important case, and people are talking about it a lot at the moment because the 50th anniversary is this year. So I have a handout for you on that too. I'm probably going to give a bunch of handouts, and if you're not interested, actually don't take them, because I didn't print enough for everyone. So if you're not interested, it's not a big deal. So that's libel. It'll vary from country to country. Ireland is probably strict enough. It's probably easy enough to get a libel award against someone in Ireland. In the US, it's harder. And of course, there'll be different rules as well. I mean, if you're a celebrity and things, there are lots of things to consider. And a lot of those issues are dealt with in that News U course. You also have an issue nowadays where you have jurisdiction shopping. And so if CNN.com publishes something about me, let's say they pick up that lecturers taking drugs and sex from exchange for passing students story and run with that, right? Every place that's been published, the libel would have occurred. You might find that some countries' legal systems are very strict about libel and some aren't. And so people will, in the case of a global libel, go for the country where they're most likely to win. So you might find one Australian says something nasty online about another Australian, and he thinks he's been libelled. He might head off to London and sue that person there rather than in Australia, because he might be better off. In London, he might be more likely to win. You see jurisdiction shopping a lot as well in patent cases, for example, where Apple and Samsung will pick their battles in places they're more likely to win. So that can be an issue if you are publishing something that's available everywhere. I mean, 50 years ago, if the Irish Times published something and libelled someone, I mean, that libel would really only have occurred in Ireland. They wouldn't be taking themselves off to Australia to say, that person libelled me there too. Because the chances of someone reading it, the number of people that in Australia that would have read the Irish Times would be quite small. The number of people that read the Irish Times in Australia now is quite large, because they can do that online. So that's libel, and it's probably the biggest hazard you have to consider. I have some more handouts, but you have cases of, friends falling out and one ending up libeling the other, and all sorts of things. Because of course, people can post stuff on your Facebook wall once they're your friends. They can say things about you, and lots of people can read them. Now, so there are some other things then you have to consider. Again, we're talking about Ireland, but there are things like this in lots of jurisdictions. So in Ireland, we have the Prohibition of Incitement to Hatred Act, 1989. From time to time, we hear of someone possibly being prosecuted under this. I don't know if many people have. But this prohibits you from encouraging people or making statements that might lead others to act against people of certain religions or races or sexual preferences and stuff. So if I was to start preaching that we should round up all the ginger people and kill them, I could possibly be prosecuted under the Incitement to Hatred Act. There was actually, now that I think of it, of course, the most topical libel case in Ireland was when a gay man accused anti-gay people of being homophobic, and they sued the television station for libeling them for publishing this, and the TV station settled. So that's a big thing going on at the moment. Anyway, so you have to be careful about dealing with race and religion and sexual preference and things like that, depending on where you are. There's a case of, well, I probably have them on the list there, don't I? At the very start. I'll come to that in a minute. So there are some, these are all under the general, these are all roughly lumped together. Blasphemy is another thing. It's not confined to devoutly Muslim countries. The Defamation Bill 2006 was signed into law in Ireland in 2009. Actually, up to that point, it's been blasphemous. Well, you can blaspheme in Ireland since a long time ago. I don't think there has never been a time in the past couple of 100 years when blasphemy wasn't a crime in Ireland. So we can cue the Monty Python sketch and whatnot. The 2006 Act, which came into effect in 2009, defined it a bit more. The nature of blasphemy in Ireland has evolved over the years. So a long time ago, its main purpose was to secure the Anglican, or Protestant as we might call it, religion in Ireland as the primary religion in the country. And so a long time ago, even denying the existence of God would have been a crime that could have been punishable. The latest form of blasphemy in Ireland is really more closely related to incitement to hatred, I think, than it is to the old concept of denying the existence of God. And it's largely a ban on acting the bollocks and deliberately insulting people of different religions. So if I was to go out of my way to say nasty things about, the Prophet Muhammad, peace be upon him, just to piss people off, that could land me in trouble. Again, this is one of those laws that's on the books. I doubt if anyone has ever been prosecuted. At the same time, if you could be fined €25,000, it might put manners on you. The question is really, when it comes to God, is it the job of the state to put manners on people and to say what you can say about God and what you can say about his prophets or her prophets? Did get struck down there. Okay. So you might find that in other European countries something like this would be laughable, but the UK had a blasphemy law until quite recently. There was a big case of a woman from the UK who was being prosecuted for blasphemy in a Muslim country where she was living, and the quite reasonable response to that was, well, the UK has blasphemy laws too. What's your problem? There's talk now of removing the blasphemy laws in Ireland. And in countries where the state is very separate from religion, the whole concept of blasphemy wouldn't fly. But we don't have a huge separation of church and state in Ireland. So if you say something blasphemous that could upset people of a particular religion, and I suppose the only redeeming feature of this new blasphemy law is that it's an equal opportunities blasphemy, in that in the past you could only blaspheme against the Christian God, where now you can blaspheme against them all equally. You could theoretically be fined €25,000, which is a bit of a constraint on your free speech. And it's also interesting and troubling that the measure is the likelihood of offending particular people. It doesn't obviously deal with the actual existence of God or otherwise, but rather that you might upset some people. And so there's a reasonable argument to be made that, it's not the job of the government to stop us upsetting each other, and that free speech is more important. So, there are a whole bunch of ways in Ireland to get yourself into trouble. So you can, say things about people that aren't true. I think if you are going around deliberately damaging people's reputations, and when I say deliberately, in some jurisdictions, they may look at the intent as well. So if you slip up and accidentally harm someone's reputation and apologize profusely afterwards and make it clear that you made a mistake, that might be okay. If you go out of your way and it's deliberate, it might be a different scenario. You can also cause other people to do stupid things and it come back on you. So if you now go around and beat up some ginger people, I'm the one that might go to jail. And you could also get into trouble for dissing God or any of his prophets. So that can be a problem. There's another thing I had on my list there, which I haven't a separate slide for, but there's the whole issue of denial. The hate speech sort of comes in there into the incitement to hatred. But the whole concept of even denial, I have a handout for you. There's a guy who for many years was denying the Holocaust. And if you go around claiming that the Holocaust didn't actually happen, as well as being a complete fucking muppet, you could actually be breaking the law in some countries. So this man, despite having been told, I think, not to ever come back to Austria, went out of his way to go to Austria to argue that the Holocaust didn't in fact happen, and he was arrested and put in jail. And the problem there, well, I mean, he was a fucking muppet in fairness, but so it's hard to defend him. But the issue is there are other of these things. I mean, until recently there was a proposal in France to make the denial of the Turkish genocide of Armenians about a century ago, to make denying that a crime. Now, I don't think that was passed into law, but there are these other problems as well. So I mean, in some respects, if you think about Galileo, I mean, he came to an unpleasant end because he was claiming that the sun was the center of the solar system, So you can get into trouble, but I don't know why I thought of that, because the Holocaust was a fact as well. So yeah. No. So one of the issues then is that because the internet is everywhere and sort of nowhere, even if you're publishing in Ireland, you might, for example, if people start reading your blog in the United Arab Emirates and you start saying things about perhaps the government there or perhaps the Prophet, then you might be landing yourself in trouble there without realizing you have a huge following in the United Arab Emirates. And then you go on holidays in Dubai and all of a sudden you're going to be like thrown in jail or something. So you do have to kind of consider what you're at, but at the same time, you can't possibly be aware of every law everywhere and make sure you don't offend anyone anywhere. And I mean, we can't expect to be held to the standards of, say, Saudi Arabia. I mean, look at the women in the class, look at the way they're dressed. I mean, it's disgraceful. We can't expect to be subject to all the laws everywhere. But the problem is that if you're publishing, you're kind of publishing everywhere. And so there are some issues there. So some interesting stuff there that you might want to consider. But the main point is that the concept of free speech is one that is held dear in most Western societies. But I think we would all agree that there are limits to that speech and that it's constrained and so should be. So even though we obviously don't have a First Amendment in our Constitution, we don't have anything like it really. Even in Ireland, the idea that you can criticise the government, that you can criticise policy, that you can engage in debate, that you can publish your opinions, these are things we hold dearly. It's hard, I think, like I said, for us sitting comfortably in a free society to truly appreciate this. But if you find an Irish person over 40, you would be shocked at the kinds of things that would get you into trouble even not that long ago. And find an Irish person over 50 or over 60 and they can tell you all sorts of horror stories. But Ireland has changed an awful lot in the past 20, 30 years. So it's not so easy for you to appreciate the value of some things. So any questions or any thoughts on any of that? Go on. Okay, keep going so. So next thing I want to talk about then is intellectual property. And obviously when most people think about law and internet, they immediately think of copyright and intellectual property. Okay, that's unfortunate. Now those graphics didn't come out. I'll have to fix those for the next class. So there are different kinds of intellectual property. We're going to look at 4 different kinds over the next few classes. So there are patents, and patents are for new inventions, and you can get yourself a patent by applying for one. And we'll talk about that. We'll talk about that in more detail than is necessary for you really, but I find it a little bit interesting, so you just have to indulge me. Copyright is very important if you're publishing online. And understanding what is acceptable and what's not is essential really. You're much more likely to run afoul of copyright legislation than you are of blasphemy, for example. Trademarks are identification for products and services. And you can get those just by using them, but you can also register them. And then trade secrets are information that you have that's valuable that you try and keep secret. And so these are the four main kinds of protections we have for intellectual property. Obviously, in the past 25 years, or even the past 10 years, the nature of how we relate to intellectual property has changed quite a bit. And copyright is really under siege at the moment. And in some respects, we're wrestling a bit with patents as well. So, if we take some examples of intellectual property, we take Coca-Cola. That's one of the world's most famous brands. So Coca-Cola is like a trademark. But also, we heard something about Coca-Cola's, secret recipe. So there's a secret at work there as well. If you take, say, an instant camera, like a camera that used print pictures straight away, there was lots of patents associated with that. So these are like inventions that were protected. If we take, say, an Apple iPod, we have like the Apple logo, the Apple brand, that's a trademark. iPod is a trademark. There's the look of an iPod. So even if you make something that is not from Apple, you can't make it look like an iPod either. There's kind of a copyright issue there. But also there may be many inventions inside an iPod that are protected by patents. There may even be things that Apple hasn't told anyone. They might be secrets. So there's a variety of different kinds of intellectual property. And we're going to look at all four of them very briefly. I think the most important one when you're publishing online is copyright. So copyright gives protection to an author that prevents others from making copies of his work without permission. So if you have a creative work, other people aren't allowed to copy it. In order to get copyright protection, the work must be original. The threshold for originality is actually quite low, in fact. It doesn't have to be super brilliant, fantastically original. It just has to be and it has to be fixed in a tangible medium. There was some discussion as to whether that medium had to be readable by humans. So in the early days where they had these pianos that would play automatically, kind of a paper roll that would play music, there was some discussion as to whether you could copyright that or not, because a human couldn't actually read it. But that's not a requirement anymore. It just has to be in a tangible medium. So a tangible medium could be on your hard disk even. But so if you write a song and you record it, or you write a poem and you put it down on a piece of paper, once you've committed it to some tangible medium, you have your protection. As long as that poem or song is only in your head, you have no protection. And you can't copyright an idea. You can copyright, copyright protects an expression of an idea, in a sense. So this is important. The most important thing about copyright is that it exists automatically. You don't have to do anything to get copyright. You might want to take steps that would make it easier to demonstrate that you're the original author in the event of a dispute. But, if you write it down in a notebook and it's sitting there in your bedroom in tangible form, the copyright exists from that point. Copyright holders then have exclusive rights to make copies of the work, which is fair enough, but also to produce derivative works. So translated versions are movies. Also to distribute copies. So even if so there may be a situation where someone imports a book or a shipment of books from somewhere, but you have the copyright in that country and they don't. You might be able to stop them even selling the books, even if they printed them somewhere else, things like that. Perform works in public or display works in public. So the idea is that if you create an artistic work, you have control over who can make copies of it. It is interesting that technology has advanced for us to need such a thing. I mean, when the Book of Kells was written, there was no copyright. But copying books was very labor intensive. But with the advent of the printing press, it became possible to make copies, and lots of them, quite cheaply. And it's interesting that as a society, or as a culture, or as a people, whatever, as a species, we decided that we wanted to value intellectual works and give people rights over them. I mean, it's easy to understand how humans have this concept of property, and if I have a field, it's my field, and I get to decide, what crops grow there, and I get to keep the crops and sell them and do whatever I want with. The idea that if I write a poem, it belongs to me, and only I am entitled to get benefit from it, or I'm entitled to be rewarded for that. That's quite a sophisticated and quite a clever trick, really, as a culture that we developed. And the purpose of copyright is to allow authors to derive benefit from their work so that they might be able to produce more and to share it with us. So if you can imagine J.K. Rowling spent time writing the first Harry Potter book. If it wasn't possible for her to make money from that, well, she might have had to get a real job. She might have had to get, a job in Tesco or something. But because the copyright mechanism allowed her to make money, she was able to not go to Tesco, but stay at home and write more books. And similarly, with other kinds of artists, like musicians, the copyright mechanism allows them to keep creating their works rather than doing something else. So imagine, for example, I was Ireland's greatest rapper, or the world's greatest rapper. Sure, why limit myself? So I'm in fact the world's greatest rapper. But if I can't make money from that, then I would have to stick with this job. I have a mortgage, I have kids. So the copyright mechanism would allow me to continue rapping, making records, whatever they're called now, and selling them and making money, and so I could quit my day job. And so the copyright system we have is like a contract between artists and society. You produce your creative works, and we'll make sure you can get some money from that. And that was a reasonable enough exchange that worked quite well for a long time. It's difficult nowadays to enforce copyright for some types of work. So as we know, the music industry is largely under siege because it's possible to make perfect copies of things once they're in digital form. So when a song is in digital form, it's just stored as numbers. You can make a copy of the song by copying the numbers. And so cyber technology poses real challenges to copyright. There are also cross-border complications because if a song is hosted in one country and is being downloaded in another, how do you stop that? Where's the crime taking place? In most jurisdictions, copyright lasts until 70 years after the author's death. Used to be 50 years in quite a lot of places. And there's all these transitional arrangements as well. So at the moment now there's an interesting case, the case of Sherlock Holmes. So for works produced during the time that Arthur Conan Doyle wrote the Sherlock Holmes books, the copyright period is for 70 years after the author's death or 95 years after publication in the US. So Arthur Conan Doyle is dead 70 years now. So in the UK, you can do whatever you like with Sherlock Holmes. In the US, there are 10 books still with copyright protection. And you have an interesting scenario because you have the right to control who makes derivative works. If you make a Sherlock Holmes movie, for example, you have to pay Sherlock Holmes' estate some money. You have to get their permission. But now, you don't have to do that anymore, at least in the UK. In the US, and I have a handout on this for you too, another one. In the US, his estate is arguing that because 10 books are still protected by copyright, then Sherlock Holmes as a whole is protected by copyright. Whereas the counter-argument is, well, yeah, obviously we can't copy the 10 books that are still under copyright, but all the other books that have expired, we can do what we want with those. So if, for example, in one of the 10 books that are still under copyright, we learn that Sherlock Holmes is allergic to cheese or something, you can't use that now in your Sherlock Holmes movie. You can only use the stuff from the previous body of work. So there's all these interesting anomalies, and it used to be a time when it was 50 years in the US and 70 years in the UK and Ireland. So you'd go to a website and it might say, if you are in Ireland or the UK and list of countries, you can't read this. Don't click here. And that's about as much as they could do. I mean, you're still going to click, It's been harmonized a lot now to a lot of countries, and it's 70 years. What do you think of 70 years?
Excessive.
I think it's a bit long, yeah. I think a lot of people would argue that 70 years might be a bit long. I think it's reasonable that an author should be able to make money off their work, certainly while they're alive. I mean, way back, it was a much shorter period, and you might have to renew it. So if it was a work that was still generating income for you, you might go and register and renew it and stuff. But 70 years is a long time after you're dead. I mean, the main purpose of copyright is to incentivize the production of work. So if I can make some money from my rap music, I might make some more of it. It's hard to incentivize dead people, really. It's not easily done. Also, I mean, it's maybe reasonable that, if I'm on the road a lot, because I have my concerts and stuff, my kids might be missing out on me a bit. Maybe, even after I'm dead, they should still be making a bit of money. My grandkids, I don't know. No, I doubt, It'd be interesting to see what's still making money 70 years from now as well. But some people have argued that 70 years is a bit too long. But then some people argue we shouldn't have any copyright at all. I can copy whatever I want, wherever I want. So it's hard to find the right balance there. Any questions on any of that? So copyright is a big deal if you're publishing online. You can't just go taking stuff and pasting it. It's wrong, it's morally wrong, but it's also against the law. It also pisses off the Google bot too. Google isn't interested in duplicated content. So in the next class, we'll look a bit more at some copyright issues, and we'll look at the other kinds of intellectual property also. If you haven't taken that News U course, or if you just really didn't take it but just did the multiple choice exam so often that you got the 90% I asked you to get, it might be worth going back and having a look at least at the copyright part, because that's really important. Well, actually, the libel part is also really important. In fact, all of it's really important. So go back and have a look at that. Great stuff, guys. Thanks.